Most people that call us for an injury that they've sustained on the job have been injured because they're full-time workers, full-time employees. They get injured and it's pretty standard. And sometimes though, if you're working part-time, or let's say you're a temp worker, let's say you're doing a seasonal job and you get injured and it's right before the season, right after, etc., are you covered? And the short answer is yes, but you face a lot of different issues than full-time workers. And that's what we're going to talk about today. Hi everyone, this is Britton Morrell with Kaplan Morrell. We are Colorado, Denver, Front Range, anywhere in Colorado lawyers helping people with on-the-job injuries. That's what we've been doing since 1995, and we would love to help you if you need it, so just stick around and we'd love to help you. If you have any questions, please like and subscribe, ask questions. We're happy to do it in the comments below. And again, as always, if you've been injured on the job, give us a call. We'll give you the information on that a little bit later, but with that, let's dive into it. In this video, I'm going to discuss about the special kinds of problems, hazards, traps, what you want to call it, difficulties that workers who get injured on the job and they're not full-time employees, either part-time workers, they're temporary workers, seasonal workers, what extra challenges do they face if they're injured on the job? And more importantly, how can an attorney help them get the benefits they fully deserve? So let's talk about the kinds of work situations I'm talking about when I talk about part-time work. So there's obviously, for example, the part-time person who only comes in not 40 hours a week, maybe 10 hours a week, maybe 20, maybe 30. They are not considered full-time employees. And also in that group, I'm also including seasonal workers. So let's talk about probably the most common seasonal worker there is, and that is teachers. Teachers tend to work maybe August up through May, and then they're off during the summer, and then they come back up in August, and then they work till May, etc. But other seasonal workers could be landscapers, snow removers, sometimes construction, roofing in Colorado can definitely be seasonal work where you're working more in the summer than the winter, and sometimes you're off entirely during the winter. And then finally, we have what we're called temp workers. So these are people who work for temporary work agencies, and they're placed with certain employers during jobs, and sometimes those jobs may be just for a week, maybe they're for 3 months. Sometimes those temp agencies place you with an employer, and the whole idea is you're going to work there for maybe 6 months, and hopefully that employer is going to offer you a job working directly for them. That's kind of a temp agency, temp workers. All of those folks I'm going to talk about as part-time workers, and they all face different issues when they're injured on the job. First big issue they have is, what is their average weekly wage? Do they get the same benefits? Yes, they absolutely get the same benefits. If you are an employee and you're injured on the job, I don't care if you're injured the first hour you've worked, if you only work 1 hour a week or whatever, as long as you're injured on the job, you get the benefits. And what are those? Well, you get your medical care 100% paid for, you get mileage to and from doctors, you get compensation for an impairment rating, disfigurement, etc. But what part-time workers face is what is their average weekly wage? What is that going to be based on? Now, the law says is that you would take your wage at the time of the injury, and we multiply it by the hours you worked each day or would have worked had the injury occurred, and then we multiply it by the days you would have worked that week had the injury not occurred, etc. And so the issue is that the insurance company is going to be kind of happy because a lot of your benefits are based on what your average weekly wage is. And if you have a part-time wage and you're not making, let's say, $400, $600 a week, but you're only making $300 or $200 a week because you're part-time, the insurance company is going to go, yay, we get to pay that person less for lost wages, and in many cases, they get to pay you less for the permanent impairment rating you're going to have. What we need to do as your attorney is fight to get that average weekly wage to take into account the entire picture of your economic life, not just that one job with that one part-time job. So how do we do that? Often with part-time workers, we look to see, is there another job? Are you doing part-time here at this job and then elsewhere you're doing another part-time job? If that's the case, then we're going to work to make sure that your average weekly wage includes both jobs wages, not just one, especially if the work injury not only takes you out of doing the job you were doing when you were injured, but also causes you to be off work to do this second job. We definitely fight to get that covered under workers' compensation. Now, what if you are a seasonal worker and you work a lot of hours, let's say during the summer months, like say from May to October, you are doing gangbusters because you're up on a roof doing roofing. Maybe it's just the growing season. Again, you work a lot during April through the growing season, harvest in October, and then November, December up through you're off work entirely. What if during the start of the season you kind of earn a little bit less because you're not working that much? Maybe it's 20 hours a week to start off with and 30 and 40 hours a week. But in the height of the season, you're putting in massive amounts of overtime, okay? Now, if you get injured at the beginning of the season when things are low, the insurance company is going to say, oh, sorry, the law says that it's your wage at the time of injury, and poor you just had bad luck to get injured in the low season rather than get injured in the high season. And my thoughtful legal response to that argument from insurance companies is, no, that's not the way it works, okay? Especially if it's kind of a job that you do year after year after year. What we're going to do is we're going to argue that you should be entitled to your average wage over the year divided by 52, etc. But it should take into account your actual earnings. What happens if you've got a seasonal job? And again, like my example, let's say the teacher, where again, from August up through May, you're working hard, you've got a full-time job, and then come summer, June, July, you do another job there. I'm going to argue your average weekly wage should include both jobs so that you get the full benefit of your actual economic loss and impact from your work injury. Another thing I see sometimes, particularly with temp agency workers, is some companies, rather than hiring people directly and try to see will they work out or not, they'll hire a temp agency to send in workers. And the agreement is, okay, we're going to try them out for a month, 3 months, 6 months. And then if they work out, we can offer them a job working directly for us. And it works for everybody. You get a chance at the job, the temp agency gets to put people there, and the employer gets to kind of see, who do I want to hire? Is this person good or bad? I'm going to extend them an offer if they're great. So what happens if you get injured on the job and as a result, you don't get an offer from the place of employment where you're with? Now, first of all, if you're injured on the job with a temp agency, let's say you work for temp agency Alpha, and Alpha sends you to Beta to work, and you get injured while working at Beta, you have a workers' compensation claim, not against Beta, but against Alpha. Alpha's workers' compensation insurance company is going to cover you. Even though you were injured working with Beta, your employer is Alpha. Now, what I've seen sometimes happen, and if I can get proof, typically it's got to be in writing, where, hey, look, we would have made you an offer, or I've had some people who actually had an offer. Hey, at the end of your temp period, starting on July 1st, we're going to have you work directly for us, and then don't you know, June 2nd or June 10th comes along, my guy gets injured on the job, doesn't get the new job with the new company and the increase in pay. And if I've had that job offer, I have been successful in getting the average weekly wage increased, not because of the work they were doing for the temp agency, but because of the job that they lost due to the injury. Again, it can get complicated. But if you've on a temp agency and that's your situation, you need a lawyer. Finally, for part-time workers or temporary workers or seasonal workers, I've seen this happen a lot of times, where you have a job where it's going to keep going and it's going to end, the assignment's going to end, let's say, April 30th. Or you've got a seasonal job where the season just ends April 30th. Or you are working for a school district and the job ends April 30th because school lets out. Sometimes what insurance companies will try to do is shut off your lost wage benefits. So you're working, you get injured, let's say February 1st, and then April 30th, your insurance company goes, well, you would have been off work anyways after April 30th, so May 1st, we're not going to pay you lost wages. Let's say you get injured on the job and they accommodate you, but now the position ends and you're no longer getting accommodated, and you ask for, hey, I got injured, I have restrictions, I'm now no longer working, I'd like lost wages, and the insurance company says, sorry, you would have been off work anyway because the job was supposed to end. Do you have any rights? And the answer is absolutely you do. Okay, I hate this argument from insurance companies, because what insurance companies try to do is they try to say, listen, you would have been off work anyway. Yes, that may be true, but it also may not be true, because maybe my client would have then gone look for another job. I've had cases where school employees at the end of the season, they got different jobs, or they applied for and worked with the school district for off-season jobs, etc. So the law is if the job in any way affects your ability to work, you should be getting lost wage benefits during your treatment while you have restrictions. Last thing I want to talk about that temp agencies and temporary workers with temporary agencies face is temporary agencies have a much easier job of offering you a new position, a temporary assignment within your restrictions, and if you do not accept that offer, you can lose your lost wages a lot easier than a regular employee, okay? So if you are a temporary worker, or if you're a worker with a temp agency and if you've got restrictions, you need to be very careful and very responsive when that temp agency offers you employment modified to your current restrictions. If that happens, you need to make sure that you're saying yes, you'll do it, and trying it. But most importantly, you should be getting a consultation with a lawyer like us, because we'll help you navigate it and make sure that if you're offered a proper job within the restrictions, that you're able to take it. But if you're not offered a job within your restrictions, we advise you on how to turn it down so you're not jeopardizing your lost wage benefits. So you can kind of tell it is really fact dependent based on what kind of worker you are, temp agency, seasonal, part-time, whether or not you've got other jobs, other gigs that you're doing. If you are, you really need to get legal counsel so that when it comes time to compensating you for the true economic impact of the injury, that you are as covered as you can be. Please, if you've been injured on the job, if you know somebody who's been injured on the job in Colorado, give us a call, give us a text, come visit our website. We would be happy to help you. We offer complimentary consultations, absolutely free. We can tell you what your rights are. We can answer your questions. If we think we can help you, we'd be happy to, on a contingency fee basis, which means you don't pay us unless we get you benefits. And with that, thank you for spending part of your day with me.